Welcome back. I'm Justine Galvin, and this is the Law Down Under. I'm very excited to be back in the studio today, where we're going to be talking about quite a controversial topic recently in the media, considering the recent elections, both here in Australia and in the US. And with people asking, are the executive taking over our government? And that is the separation of powers. So essentially, the Australian Constitution itself frames the authoritative sources of executive, legislative and judicial power into three distinct branches. Chapter 1 vests power in the legislative, which is the power to make laws, and that's in the federal parliament, which is the House of Representatives and the Senate. Chapter 2 gives the executive power to enforce laws, and that's made up of the King, the Governor-General, the Prime Minister and the Ministers. And Chapter 3 is judicial power, which establishes the High Court and other federal courts are an executive body to review and interpret the law. Now, this embedded separation is designed to vest each branch with respective powers and responsible to act as a check and balance on the other powers, which is ultimately to prevent any one arm of government from becoming too powerful. Now, our constitutional structure was framed closely by the United States. However, our separation of powers here is only applied in a limited form. But as decentralisation of power is a key feature, and it's only limited, are people correct in their concern that it's failing? So let me welcome today's special guests, Hallie, Jack, Damien and Jessica, who are going to talk to me today about whether the current and practical operation of separation of powers is really appropriate at the federal level. Good afternoon, guys. Thanks for joining me. I'm really glad you can be here. How's everyone going? Pretty good. How are you?
Too much immigration increases house prices, creates congestion and stress on our roads, hospitals and schools. Restore the balance. Vote 1, Trumpet of Patriots.
Today I wanted to discuss a few topics with you, so I think we should just get straight into it. So as you know, here in Australia, our government has a two-party system. Dan and Jess, I was hoping you guys would be able to talk us through whether this system has influenced the intended balance and independence among the three branches.
Well, Josie, the two-party system provides a healthy balance throughout the branches and through checks and balances. If the one-party system in Australia existed, the party would be able to manipulate the powers to its liking to push decisions among the public. The opposition is there to question government, challenge legislation, and holds ministers accountable, which ensures that the executive branch doesn't become too dominant. Proposed bills have been agreed to by both Houses of Parliament to become a law. Also, it provides the opportunity for legislation to be debated and amended, ensuring that laws undergo scrutiny. This way, the impact of legislation is properly assessed through debates among parties. Arrangements for multi-party government may require negotiations and written agreements with various independent stakeholders, which ensures that decision-making is a majority.
Because ultimately, if we had a one-party system, legislation needs to be passed with absolutely no debate. Everything would be completely one-sided and there'd be no consideration of the legislation's actual effect. Okay, thanks guys. So it sounds like the two-party system is appropriate at the moment in Australia. But I just want to come over to you, Jack and Hallie. When we look into the two-party system and its historical dominance of Australian federal politics, what influence do you think it's had on the separation of the parliament and the executive branch?
Well, I think if you want to understand the two-party system and how it's impacted on the separation of powers in Australia, you really have to understand responsible government itself. So responsible government in theory and practice essentially says that members of the executive branch have to be drawn from and remain in Parliament while serving as ministers. This feature is supposed to afford Parliament sort of supremacy over the executive, ensuring that Parliament can keep members accountable and throw the government or individual ministers out of office if Parliament loses confidence in them. So by definition, then, responsible government really nullifies that division between the executive and the legislature. But if you look at Parliament's composition over the last decade, back to about 2013, the five now since the election, the five parliaments formed since 2013 were each characterised by lower house majorities, held by either the Labor Party or the Coalition. So if you look at 2022, for example, 2022's federal election resulted in the ALP having a majority of 77 seats in the lower house, the Coalition in 158. But if you look at 2025, we just had 2025, the ballot count isn't finished yet, but if you look at where it currently stands, we've got Labor with, according to the AEC, with 91 seats. We've got the Liberal Party with 43, So Labor essentially has a huge majority. They'll be able to get through whatever legislation through the House, the lower house that is, whatever they want. And moreover, they'll be able to appoint whatever ministers from their party, from their own ranks, just as the coalition did in 2013, 2016, 2019, and the Labor Party did in 2022. So essentially, we've got party monopolies over the executive branch that originate from party dominance of the legislature.
We have an abundance of coal and Australia needs to play to its strengths. We need to scrap net zero and lower your cost of living.
Okay, so now we can recognise our system is one of responsible government. So how does the role of minor parties actually influence the separation between these two branches, especially when major parties still dominate both? First of all, Josie, I think it's incredibly important to recognise that these minor parties who typically correspond with a broader public interest, they're no longer playing minor roles in our government, particularly in our legislative process, especially when we consider that the Australian Constitution doesn't actually enshrine a strict separation between the legislative and the executive. Minor independent parties are really imperative to upholding a local allocation of power. If you draw a comparison to the US Constitution, although the inclusion of minor parties in that system are heavily restricted because they have such a strong two-party system, there is already a really strict separation between the legislative and the executive in the Constitution. So particularly when proportional representation was adopted in 1948, this really strengthened the Senate's distinctive role as an active chamber because these minor parties were being elected in proportion to the votes that they were receiving. So they were able to truly scrutinise and to hold the government branches to account. This ultimately was through two types of extensive committee systems. Tell me more about those. So two in particular, we have the Senate Legislative Scrutiny Committee. So they would scrutinise all legislative instruments and proposed bills. And then the Scrutiny of Delegated Legislation Committee, they would examine delegated instruments just to ensure that they remain within the boundaries of their primary act. And I think this is really of particular importance, especially these days, because delegated legislation is extremely relied upon, because parliamentary time is limited and we need effective responses from our parliament. So ultimately, these committees prevent overlapping of interest from our major parties, because the distribution of minority interests will allow in-depth examination of the bills, and particular matters that may be of pressing importance, yet are irrespective of our major parties, will be detailed under the agency of minor party scrutiny. Thanks, Jess. So you're saying this rise of minor parties has changed the game. It's created a more nuanced balance of power where independence and smaller parties becoming essential in ensuring that separation of powers is maintained, particularly in holding the executive accountable. What are your thoughts on this, Helen?
Well, if you look at the 2010 to 2013 Labor government, this suggests that a minority government could indeed facilitate greater separation between the executive and the legislative branches, but you will see that there are some limitations to this idea. First of all, even though the executive may not have majority, minority governments are not necessarily required to share executive power. The Prime Minister, for example, during the Gillard minority government, still excluded minor parties and independents from actual executive positions. While there are policy concessions made in exchange for support of Parliament in things like carbon pricing and funding for regional areas, the executive power is still concentrated in the hands of the Labor government, and minor parties did not have a seat at the executive table.
Only one Australian flag that represents all Australians. We don't need to be welcome to our own country. Vote 1, Trumpet of Patriots.
Second, although past electoral results indicate that minor parties may gain seats in future elections, the outcome still remains entirely expected. Take, for example, this year's 2021 election. At the time of recording this, the Greens have won 0 seats. They've definitely lost 2 seats to Labor, and the seats they won back in 2022 are still in doubt. They may end up with no seats. In addition, although the independents seem to have more or less entrenched their position, they're actually now down 10 seats in the last parliament to 9 in this parliament. The point here is that they haven't substantially increased their share of the House of Representatives to the point of including a majority government, like some commentators were predicting. These indicate that the separation of powers in relation to minor parties is well imperfect. This highlights a structural limitation to the separation of powers in Australia's parliamentary system, where the executive retains substantial control over the direction of the country, and minor parties still remain excluded from the executive process.
Okay, interesting. So far, we can see that this really is a controversial topic. I think whether it's appropriate isn't really a clear-cut yes or no, like we thought, especially when we look at both of your sides and we compare it to the United States. So, since we've talked about separation of powers between the executive and the legislature, I want to talk now about the judicial branch. Is it fair to say that the judicial branch is independent, or would you say otherwise?
I think in totality, where the High Court as a Chapter 3 court exercises the judicial functions, specifically of that of the impartial judicial review, holds the legislative or the executive branch to account where the exercise of power is unconstitutional, which continues to preserve the constitutional promise of any independent judiciary.
And I think just going on what Damien said, a notable example would be Parliament's 30 years later, the scope of the good principle was upheld and refined into like a modern rationale. So just for context, this case essentially established that there was a constitutional boundary to the exercise of judicial functions, specifically that executive detention, which is punitive in effect, is actually judicial in character.
We'd like to thank Protecting Judicial Review Incorporated for sponsoring today's podcast. As an outlet that hopes to keep all updated with all things judicial review, they have recently released a new article on how Alexander v Minister for Home Affairs that held that the executive could not adjudge or punish individuals for criminal guilt was indeed an exclusively judicial power. To be understood in light of the Lim principle, this case reinforced the constitutional protection of judicial power, specifically punitive functions, ultimately questioning whether the powers exerted were purely administrative or judicial as a check on executive power. Please see the link in our bio to exclusively read this article for 20% off today.
Well, I actually have to disagree with the notion that Australia's judiciary is completely separate and has no interference from the legislative and executive branch, especially the executive.
Yeah, tell me more.
Well, if you look at some of the studies that have been conducted of some of the High Court judges and their jurisprudence over the last decade or so, there's one particular study where they looked at one of the older iterations of the High Court, and what they found was that those judges who were nominated by more conservative governments, coalition governments such as Calnan or Gleeson, they deployed a much more conservative judicial ideology in their decisions, whereas if you actually look at some of the more liberal ALP justices who were appointed to the court, what you find is that what they found in the study was that people like McHugh or Toohey, Kirby were much more liberal and much more left-leaning, I guess, in their rulings, essentially. So even though it's sort of unclear whether this process exactly undermines separation of power, I think there's enough evidence there to suggest that the process has become very politicized, unlike some other courts.
Okay. Talking of other courts, do we have any comparative with the US?
Well, yes, when you look at the US, they actually have a much more rigid system than we do here in Australia. Theirs ensures that there are strong checks and balances between the three branches. However, they still have overlap that occurs. For example, in a case in the United States, in Nixon, it was noted that the assertion of executive privilege by the president does not grant them total immunity from judicial scrutiny. The court ruled that executive privilege could not be used to stop judicial power from performing its duties in investigations. This ultimately showed that the separation of powers is never fully being whole in either system.
Well, since we're talking about the US, in their constitution, in Article 3, the power of judicial review is not explicitly granted, yet in the case of Marbury v Madison, it ultimately established a doctrine of judicial review to safeguard the Constitution. In conclusion, among numerous constitutions, even though their practical applications may differ, the separation of the judicial branch is a constitutionally sacred principle upheld by constitutional boundaries that judicial review reinstates.
So, all in all, I think we can see that the executive hasn't taken over government just yet, as the separation of powers can work, but it still remains to be undermined and controversial in light of recent developments. So, I really appreciate you guys taking the time to come and speak with us today and give our viewers a deeper understanding of the separation of powers and how broken it is in Australia currently. So, thanks, guys, and thanks for tuning in.